Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, listen, I understand all of your disdain for the clickbaity McClickersteins out there. And candidly, there are some people out on X that have made a complete living and built a profile doing nothing more than just clickbaiting people. So I want you to understand that when I use a title such as the most dangerous argument you're ever going to read, I'm going to mean it, okay? Now, in case you think I'm being disingenuous, I do want to temper this with one thing. This is an argument dealing with Maryland's sensitive places. It's before the Fourth Circuit, and it's an argument that's being authored by both the Brady and Giffords group. So take that for what it's worth, but is it dangerous? It's immensely dangerous. Could it be problematic? It would be immensely problematic if this line of reasoning were to spread. So that is why today we're going to spend a few minutes and we're going to talk about the most dangerous gun control argument you will ever read. Okay, America, the case we are talking about today is the matter of Kipke v. Moore. You may also have heard of it under Novotny v. Moore. And as I mentioned, this is a challenge to Maryland's new sensitive places, gun-free zones, recent legislation. And the challenged areas here are state parks, school grounds, and museums, okay? So this case now is before the Fourth Circuit, and what we're going to be sharing with you today is an amicus brief that was authored on behalf of, oh yeah, absolutely, gun control laws are wonderful, let's keep them, but this is an amicus brief that is authored both by the Brady and Giffords groups, so you know exactly where they're coming from. But, and this is what I want you to be aware of, they have come up with an argument that is so dangerous that it literally, if ever adopted, could disarm Americans everywhere. I'll connect all the dots for you right now. Now, first of all, let's remember, anytime somebody's going to come up with a completely crazy, just absolutely off-the-wall argument, it's always going to be set up by what? That's right, Rahimi. And so for all the naysayers out there who thought I was being an alarmist when I said, hey, this Rahimi case is bad, and for all of you who out there were saying, nah, it's not that big of a deal, I want you to know that the more and more time goes on, the more and more I think history is going to be on this side of the argument. Because if you don't believe me, just spend a few minutes, read pages 7 through 9 on the amicus brief, which is linked up down below in the description box, and you can see how they set this whole argument up with the whole relevantly similar modern societal problems, all the language that Justice Roberts included in the majority opinion of Rahimi. But America, this is what I want you to be aware of, because starting on page 25 of the amicus brief, the amicus party here essentially argues that the First Amendment and the Second Amendment cannot coexist together. I'm not making it up. And ultimately, you will see that the argument that it leads to is that in order to ensure that democracy survives, we must disarm everyone. I'm not making it up, okay? I'm going to connect the dots for you right now. Now, it starts off, their argument starts off with kind of a simple little lead-in, such as explained above, the Supreme Court in Heller and reaffirmed in Bruin that firearms may be prohibited in sensitive places, including schools, legislative assemblies, government buildings, polling places, and courthouses. Okay, and there is, in fact, some historical tradition to support some of that argument. Okay, so it starts off really innocent, but then it takes a quick and sudden and very dark turn. In recognizing the constitutionality of restrictions on firearms in sensitive places where people gather regularly and peacefully, the Supreme Court has confirmed that the Second Amendment is not to interfere with the government's ability to preserve our right to engage in civil discourse without being inhibited by the presence of weapons. That's right. This entire argument is based on the fact that the mere presence of weapons, the mere presence of firearms will inhibit First Amendment activity. The amicus party clearly states right here, fundamentally, Bruin's reaffirmation of the presumptive constitutionality of excluding firearms in sensitive places recognizes the government's authority to protect a public sphere for democratic dialogue, democratic governance, and the reproduction of democratic community in which people can relate freely without intimidation or coercion. But of course, that intimidation or coercion only comes by the mere presence of firearms, according to the amicus party. But listen, folks, it gets deeper and darker than that, because check this out. Visiting a museum, for example, falls squarely into the First Amendment's protections of civic engagement. Museums present exhibits to the public for cultural and educational purposes. Think of that. If any place that exhibits anything for cultural or educational purposes is such a sensitive First Amendment area that Second Amendment activity is not allowed there, think of all the limitless possibilities of where you could be disarmed. Now, I said earlier that they believe that just the mere presence of a firearm actually constitutes coercion or intimidation or things like that, even though for most instances it would be a concealed carrier and one would not know the firearm was there. Don't believe me? Well, check out their argument right here. Museum visitors have a First Amendment right to receive, access, and engage with this information. The First Amendment protects both a speaker's right to communicate information and ideas to a broad audience and the intended recipient's right to receive that information and those ideas. This right is impinged upon by the threat of firearm-related violence. As studies show, exposing people, especially children, to gun violence in their communities interferes with their ability to learn. So what Giffords and the Brady Group is arguing is that because the First Amendment and the Second Amendment cannot coexist, that anytime First Amendment protected activities is occurring is a place that should then prohibit any Second Amendment activities. Once again, using their own words in their memorandum, there is no principled reason the government can prohibit firearms at an event on the courthouse steps or in a legislative assembly, but be held powerless to regulate the same type of activity at a state park, at a museum, or on school grounds. Indeed, such regulations, which reflect in part fundamental First Amendment concerns, are amply supported by the long-standing history and tradition. And when I said at the beginning of this that they believe the First Amendment and the Second Amendment cannot coexist, I wasn't just using speculation, hyperbole, or conjecture. No, I was using their own words, these ones. Construing the Second Amendment without the historical limitations acknowledged in Bruin collides directly with the core First Amendment protections. If more individuals or groups are allowed to carry guns in public places where people typically gather to exercise their right of assembly and free speech, it will become more dangerous to peaceably assemble, organize, march, rally, and express ideas and beliefs in public settings. That's right. There you have it. You got to get rid of the Second Amendment. It's the only way to preserve the First Amendment. That is literally the argument that Giffords and Brady is making. To further that point, take a look at this portion of their memorandum. In practice, the promise of First Amendment rights affords little assurances against hostile listeners bearing guns. The problem is exasperated in an increasingly polarized society. So you see what they've done? They have intentionally sown division into society, created a, yes, more volatile society, created a place where, yes, people do want to, in fact, exercise their First Amendment rights. Also created a situation where those on one side of the fence can exercise their First Amendment rights. Those on the other side of the fence, not so much. And because of all of the division that they have sown into the moral fabric of this country, that is a reason for which all of you now should be disarmed. Ultimately, and again, I'm not making this up, Giffords and Brady concludes with the statement that they believe that the only way to preserve democracy is for all of you to be disarmed. The exact quote from the memorandum, page 33, once again, linked up down below, reads as follows. To preserve our democracy through peaceful civil engagement, states must be able to appropriately regulate firearms in modern First Amendment protected spaces. And there it is. You have two of America's largest gun control groups now arguing that the Second Amendment and the First Amendment cannot coexist, and that the only way you can preserve democracy is to get rid of Second Amendment protections. The case, once again, is Kipke v. Moore, also known as Novotny v. Moore. We're going to link up their brief down below so that you guys can tear through it yourself. Now remember, what do we always say here at Washington Gun Law when you're about to do something or read something infuriating, okay? Hit pause, pour yourself 3 fingers of bourbon, do some breathing exercises, or grab a barf bag. You're going to need one of the three. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't worry. That information is down there in the description box. If you got an idea for video we should be doing around here, cool. Click on that link right there and let us know all about it. If you want to subscribe to our monthly newsletter, the ability to do all of that is right down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.